The most common types of leaves of absence from the office include sick days, vacation days, or personal time off. Most companies offer this time off as part of an overall benefits package to its employees. These benefits not only offer the time off, but the employer usually pays the employee for this time. However, in more recent years, federal law requires many companies to also give employees unpaid leave from work. Welcome to CSO's FMLA Compliance Training Program. As an employer or manager, it is your responsibility to understand the Family and Medical Leave Act, or the FMLA, when it applies to your company, and the situations that are covered. In this program, you will learn who is eligible for FMLA, as well as the limits, benefits, and return to work rights. You will also have a chance to review common FMLA situations and test your knowledge on handling these cases. Finally, you will learn proven tips on how to update your company's policies, avoid common FMLA violations, and prevent FMLA abuse. The FMLA establishes a minimum leave standard that applies to any company with 50 or more employees and all state and local government employees. In calculating 50 employees, employers must include all employees on the payroll, including full-time, part-time, and employees on leave of absence. Additionally, companies must include non-payroll employees, such as temporary workers. Under the FMLA, covered employers must provide up to 12 work weeks of unpaid leave within a 12-month period for the following 3 situations. 1. Birth of a child, adoption, or placement of a foster child. 2. To care for a spouse, child, or parent with a serious medical condition. And 3. An employee's own serious health condition. In requesting leave to care for a child with a serious health condition, the employee is eligible whether the child is a biological daughter or son, or an adopted child, foster child, stepchild, or disabled adult child. In requesting time off to care for a spouse, it may include a husband, wife, or common law spouse in states that recognize common law marriage. Okay, it's time to test your knowledge again. True or false? An employee can periodically take Fridays off to care for his mother with a serious medical condition. The answer is true. The Family and Medical Leave Act allows an eligible employee to take up to 12 work weeks of leave to care for a child, spouse, or parent with a serious health condition. This leave can be taken all at once or intermittently within a 12-month period. Therefore, this employee can take Fridays off to care for his mother. Allison recently joined a small consulting firm as a part-time bookkeeper. After years of unsuccessful fertility treatments, she and her husband have decided to adopt a little girl. Is the consulting firm required to give her FMLA leave to cover her adoption? If you said no, that's correct. Since Allison is only a part-time employee and she hasn't worked for the company for a year, she is not eligible for FMLA. Also, the small consulting company has less than 50 employees, so it's not covered by FMLA. Let's try another one. Remember Pregnant Pam, the advertising account executive? Pam has decided to only take the 8-week maternity leave her company allows. While out on maternity leave, she develops a serious case of tendinitis in which she cannot lift, write, or type. She was recently referred to a physical therapist for treatment, and she has requested additional time to recover. Is her employer required to give her the additional time off? The answer is yes. Although Pam is not requesting leave related to her childbirth, she is still eligible for time off under FMLA to recover from the tendinitis. And she is also still eligible for FMLA to care for her newborn.